And filed the same day.
On the 16th January, my lord.
You have to go and bring that file, big file on the table. Yes.
My lord, our process, our final written address is deemed properly filed by order of this honorable court. Today,
Yes.
the 11th day of February 2025.
Yes.
My lord, upon being served with the claimant's final written address,
Yes.
we filed our defendant's reply on points of law.
Yes.
On the 28th day of August 2024, my lord.
Yes.
My lord, we adopt the two processes
Yes.
as my lord, we adopt the two processes as our legal arguments and submissions.
Yes.
In urging this honorable court, my lord,
Yes.
to resolve all issues in favor of the defendants,
Yes.
and dismiss the suit, my lord.
Yes.
Secondly, my lord, we urge the court to resolve all issues raised in the counterclaim in favor of the defendants. And enter judgment in favor of the defendants in the counterclaim accordingly, sir. May it please this honorable court, my lord.
All right, Mr. Gan.
Sir, on receipt of the defendant's final written addresses, on behalf of the claimant, we have filed a final written address which is dated the 10th day of October 2024 and filed on the 21st day of October 2024. we adopt same.
Dated when? Dated?
It dated 10th October 2024.
And filed?
Filed the following day, 21st October 2024.
10th October.
10th October 2024.
And filed?
And filed on the 21st October 2024. Filed 21st October 2024.
Yes.
We equally adopt same as our submission. In urging the court to grant all the reliefs sought by the claimant. And dismiss the defenses of the defendant.
All right.
My Lord, may I take just 2 minutes?
Counsel, is there anything you want to say that is not in the address?
Yes,
As
just
the
to,
court labels.
just to draw the court's attention to some misleading in their
Are those
reply.
matters not taken care of in the address?
No, it's not taken care of. It is to the effect
No,
that
this is a virtual hearing, and
I understand, my Lord. It is to draw the attention of the court. It is to assist the court arrive at the just determination of this matter. And this is to the effect that our address is departmentalized in reaction to their opposition, which is to the effect that we responded to their preliminary objection. We responded to their preliminary objection before addressing the real issue. Is from page, it took between 12 to 18. Then the substantive matter thereafter. This is responding to the fact that we overshot the number of pages allowed by the rules of court. So our substantive issue, response to the substantive matter, took from pages. It's just to assist the court in writing
yes,
its judgment.
don't worry about that.
Not as if
Your objections
as the court
have been taken care of in the judgment. Yes. You raised
okay, as the court please.
you raised 3 objections. That has been taken care of in the judgment.
As the court please. As the court please.
Yeah.
Okay. That's all right, my lord.
Counsels,
Sir.
My Lord.
the court will rise for 5 minutes, and when I come back, I will deliver my judgment.
As the court labels.
Holy court.
Take your phone. Take your things. Your charger or not. Within the 5 minutes. You have taken. Eh? Eh? Oh, okay. say you will carry your food.
Because
Okay, carry on now. Enjoy yourself. While we wait for the 5 minutes.
the volume
It's
is so
good, eh?
nice.
This laptop is a modern laptop,
That's nice.
so a lot of things were taken care of. Even if you play music, the sound is so.
Okay. Your mic is off.
In the judgment of the court,
As the court
As a
is
country,
this action was initially commenced by originating summons dated the 27th day of April 2018 and filed on the 4th day of May 2018. The originating summons was later converted to a complaint by order of court the 7th day of June 2019, and the parties were directed to file their pleadings. In the statement of facts dated the 29th day of May 2019 and filed on the 7th day of June 2019, the claimant sought the following release from the court: a declaration that the claimant's employment have statutory flavor, a declaration that the issuance and service on the claimant by the defendant, the letter caption proper placement at point of entry into the universe is null and void and of no effect whatsoever, a declaration that the claimants are entitled to deductions from its members' salaries as agreed and authorized by the members through the respective forms they filled and submitted to the defendant, which information was in turn supplied to the defendant for running of the affairs of the claimant. A declaration that all members of SANU who are entitled to promotion should be promoted. An order of this court setting aside the letter served on the claimant caption proper placement at point of entry into the university for being strange to and also offending the Staff Condition of Service 2011, which regulates the employment of the claimants. An order of court that all deductions from the claimant's salaries and wages resulting from the letters issued and served on the claimant's caption proper placement at point of entry into the university is restored with immediate effect, and also the areas of a said deduction paid to them immediately. The order of this court that the claimant is entitled to deductions from its members' salaries by the defendants as authorized by its members through the forms they have individually filled and submitted to the defendant, which information was transmitted to the defendant for the running of the claimant. An order of this court that all members of the claimant who have participated in this suit in whatsoever manner or rule shall not be victimized either immediately or remotely by the defendant by any means whatsoever. Post-judgment interest of 10% on the amount deducted from the claimant's salaries as a result of the issuance and service of the letter captioned proper placement at point of entry into the university on the claimants until liquidated. General damages of 10 million naira. 11. Exemplary damages of 50 million naira. Cost of this action at 10 million naira. In support of the claim, the claimant filed a written statement on oath along with front-loaded documents. In response to the claim of the claimant, the defendant filed a joint statement of defense on the 9th day of July 2019, along with witness deposition and front-loaded documents. Upon being served with the joint statement of defense, the claimants filed a reply to the defense, along with the witness deposition of the claimant on the 31st day of July 2019. Along also with the counterclaim. Hearing in this matter commence hearing in this suit commence on the 22nd day of February 2022. The claimant testified as CW1. They adopted the two witness deposition filed on the 7th day of June 2019 and 12th day of January 2021, went on to tender Exhibit C1 to Exhibit C24, which I have reproduced in the judgment. The claimant who testified as zero was cross-examined, and thereafter the claimant closed their case. The defendant commenced their defense on the 20th day of November 2023. Stephanus Todison Gere testified as DW1. He went on to adopt his witness deposition and went on to tender the following documents in evidence. Exhibit D1 to Exhibit D12. The defense witness 1 was cross-examined by the claimant counsel, and the defendants closed their case. Brief fact of the case. Following the advertisement placed by the defendant in Daily Trust newspaper of Tuesday, November 22nd, 2011, for various vacancies for teaching and non-teaching staffs, the claimant who are members of SANU applied for the respective position vacancies. The claimant, as a member of SANU, were offered appointment as non-teaching staff of the defendant. The claimant were given letters of appointment accompanied same with the Federal University of Wukari, Taraba State rules and regulations governing condition of service of staff, of senior staff, December 2011. Upon the completion of the probation period, the claimant's appointments were confirmed by the defendant. The claimant stated that they remain committed to their respective responsibilities assigned to them by the defendant, and as a reward for hard work, diligence, and in keeping with the terms and conditions of their employment as enshrined in their condition of service, they were promoted, while some are yet to be promoted. After several years of the claimant's employment, the governing council of the first defendant came up with the policy to review all employment of members of the claimant. In November 2017, issued and served on the claimant letters captioned proper placement at the point of entry into the university. The claimant claimed that by this policy, several members of the claimant union appointment were reviewed downward. The claimants rejected the policy and their union, the Senior Staff Association of Nigerian University, Federal University Ukari branch, attempted meeting the defendants to know the rationale for issuing the said letter caption proper placement at the point of entry into the university. But the defendants refused to grant them audience. The claimant union wrote to the defendant, and in one of the letters dated the 19th day of March 2018 by the claimant solicitors, the claimant threatened to institute an action in court to ventilate their grievances over the policy. The claimant stated that it was at this juncture that the defendant immediately amended the constitution of service of the first defendant to frustrate the claimant's proposed intention to approach the court. The claimant position is that by the policy, the claimants were to have their salaries slashed by 50% and have continued to have their salaries slashed. The claimant alleged that the defendant refused to respond to their letter and resorted to threats and intimidation to weaken the demands of the claimant. For instance, they threatened to either sack life unbearable for the outspoken members of the claimant on this issue. They alleged that the defendants, in an attempt to frustrate the claimant's union, immediately stopped the monthly deduction of check-off dues in favor of the claimant from his members' salaries as authorized by the member. The claimant contended that as part of the trade, members of the claimant were surreptitiously lured into withdrawing membership with a promise of reward of undeserved promotion. In a bid to further convince members of the claimant that their promise was real, the defendant published the Federal University Ukari Special Bulletin in December 2018, where they, without regard to order, caution, and due process, were promoting members of the claimant who had trusted them and withdrew their membership, and those they termed loyal with unimaginable promotions. While these were going on, the members of the claimant who maintained their membership of the claimant were daily subjected to all manners of trade frivolous queries, punitive postings, and very degrading and inhuman treatment. The defendant stopped the monthly deduction of check-off dues for the claimant union. The claimant's position is also that the letter captioned proper placement at the point of entry into the university has no place in the condition of service of the claimant and is intended to cause industrial disharmony and therefore illegal. That the claimants who accepted this employment after transferring their services to the first defendant or resigning from their previous employment have lost their place in their previous place of work and cannot go back there. And the claimants have adjusted physically, psychologically, emotionally with their present appointment, ranks, and salary, unless the memo titled proper placement, the point of entry into the university set aside the interest of the claimants would be jeopardized. The defendant position is that the problem leading to the institution of this suit was caused by members of the claimant who do not have cognate experience and therefore not qualified to even apply for employment in the first defendant based on the advertisement for employment placed in some national dailies. That after the inauguration of the governing council of the first defendant, it was discovered that the entire non-academic staff senior staff of the first defendant was over bloated with unqualified, unskilled, undisciplined, and disloyal staff. And the ratio also, the ratio of academic staff with non-academic staff is over and above the ratio authorized by the Nigerian University Commission. This was caused by the irregularities in the employment exercise carried out by the first defendant. That the staff audit of the first defendant reveals that most members of the claimants are not qualified for appointment at the point of entry or appointment as they are over the statutory age at the time of their employment, contrary to the public service and civil service rules, and that members of the claimant do not possess the qualification and experience contained in the advertisement of the employment. Most of the members of the claimant union who transfer their services from their other universities fail to present their letters of transfer. That the first defendant governing council set up a committee to review the placement of non-academic staff at the point of entry into the service of the Federal University Ukari. The chairman of the claimants union was present at all the deliberations of the committee and also signed the report of the committee that led to the issuance of the memo titled Proper Placement at the Point of Entry into the University. It is also the contention of the defendant that members of the claimants union who are dissatisfied with the decision and recommendation of the committee of the governing council on proper placement of non-academic staff at the point of entry into the service of the first defendant are obligated by the first defendant regulations issued on the 12th day of April 2018 to explore the internal mechanism of this issues regulation at page 67 to 68 and 82 of the regulation. The first and second defendant also set up an appeal panel to review the various complaints arising from the proper placement exercise. And most of the claimants members have approached the appeal panel, while a host of others have refused to explore this internal dispute mechanism. That the first defendant has issued a new regulation in a meeting held on 12 April 2018. It is this regulation that governs the employment of the claimants. The regulation was made pursuant to the powers and authority to make and amend the regulations governing the condition of service to appointment of senior staff from time to time as expressed in clause 2 of the letter of employment of the remaining members of the claimant union who have not withdrawn their members of the claimant union. The defendant also contend that most of the claimants members have denounced their membership of the claimant union and also withdrawn the authority given to the claimant to institute this when they discovered that the officials use unlawful and unethical means to get employment with the first defendant. The defendants deny that there was any punitive posting, queries, intimidation, and degrading or inhuman treatment of members of the claimant union. Finally, the defendant contend that proper placement was not illegal, as some of the members of the claimant have not submitted their letters of transfer and have unlawfully enriched themselves from the revenue of the federal government as they have collected and are still collecting salaries and allowances over and above their lawful legal salaries. This represents the contending issues between the parties in this action. Issue for determination. The defendant's final written address filed on the 16th day of December 16th day of January 2024, the Defendant Counsel raised 3 issues as preliminary objection to this action, to wit, whether or not the second to fourth defendant who are agents of a disclosed principal can be sued along with their principal, whether or not this suit was instituted prematurely, the internal mechanism of the first defendant having not been exhausted. 3, whether or not SANU is a juristic personality to issue and to sue and be sued in its name. This court will resolve the issues raised in this preliminary objection before going into the merit of this action. The first objection. On the first issue, the Defendant Counsel has argued that the second to the fourth defendant ought not to be joined as parties to this action, and that the agents of the first defendant, who is a disclosed principal, it is his contention that there is nowhere the second to fourth defendant have acted or carried out certain actions in their personal capacity aside from acting on behalf of the university, the first defendant. He argued that there is no relief sought against the second to fourth defendant in their personal capacity. Counsel argued that where the principal of an agent is known or disclosed, the correct and proper person to sue for everything done or omitted to be done by the agent is the principal counsel. His counsel cited is the principal. Counsel cited several authorities, including the case of UVA Kundekun, citation supplied, the case of Bamboye against University of Ilorin, and another citation supplied. Counsel argued that the second to fourth defendant, being agents of a disclosed principal, cannot be sued along with their principal. This, he stated, makes the suit to be defective and ought to be struck out. In his response, the claimant counsel has argued that agency principle cannot be established between the defendants in this action. This is so because the statement of claim has variously described the defendants and the role they played in the subject matter of the dispute before the court. Counsel referred the court to the submission, to the admission of the roles played by the second to the fourth defendant and the admission by the defendant in the defense. Counsel stated that only when the defendants are joined that the subject matter of this action can be effectively determined. This makes all the defendants necessary parties to the action. Counsel relied on the case of Jimbo against Onyilole, citation supplied the case of Uzo against Nigerian Stores Workers Union, citation supplies, and the case of Okehialam against Muamara, citation supplied. Counsel also referred the court to provisions of Order 13 Rule 1 and 4 and 11 Rule 1 and 2 of the NIC Civil Procedure Rules 2017. It is also the contention of the claimant counsel that the decision relied on by the defendant in support of his objection may be good law in general principle of agency relationship, but certainly do not support this objection. None of the parties have been sued in his or her personal capacity, as is in the case. We urge the court to dismiss the objection. I have carefully considered the argument provided by parties on this issue. The defendant counsel has placed much emphasis on the case of Babi Boje against University of Ilorin and another, Supra, to argue that the second to fourth defendant, being agent of a disclosed principal, cannot be sued along with their principal. I have read this case. The issue in contention was whether the principal organs of the University of Ilorin that is the office of the registrar and the council of the university, who are vested with the delegated powers of discipline under Section 15, Sub 1 of the University Act can sub-delegate disciplinary powers conferred on them by the act establishing the university to any other body. While the decision recognized the registrar and council as agents of the university for the exercise of disciplinary powers, the court held that they could not delegate such powers. The decision did not establish an agency relationship for the purpose of instituting an action against the university. I wish to state that agency principle can only be invoked between two legal or juristic persons when it comes to institution of action against what an agent has done on behalf of the principal. This principle cannot be stretched to apply to actions instituted against a legal entity in which the principal organs are joined as defendants. This is so because the entity, like the defendant in this action, being an artificial person, can only act through its principal organ created by the statute establishing the defendant, who must be jointly accountable for the acts of the defendant. Further to this, the second to fourth defendant are not sued in their personal capacity, but are sued as organs of the first defendant. I agree with the claimant's counsel that the decision cited by the defendant in support of this issue may be good law in general principle of agency, but certainly do not support this objection. So long as very specific acts complained against in this action are attributed to the second to fourth defendant, they become necessary parties to this action and ought to be treated as such. Furthermore,
As a court, please.
Number 13, Rule 4 of the rules of this court provides person may be joined as defendant against whom the right to a relief is alleged to exist, whether jointly, severally, or in the alternative. Judgment may be given against one or more of the defendant as may be found to be liable according to the respective liabilities without any amendment. The Federal University of Wukari Act creates the office of the second to fourth defendant. By this fact, those officers become juristic persons who can be joined as parties to an action involving complaint of the actions of the occupants of that office. For the reasons stated above, it is the finding of this court that the second to fourth defendant are necessary parties to this action, and their joinder in this action does not in any way make this suit defective. The objection on this ground is hereby countenanced.
As a court, please.
As a court, please.
Second objection. On the second issue, the defendant claims that this suit is premature as the claimant has not exhausted the internal mechanism of the first defendant. The defendant contention is that though the claimants were employed during the operations of the 2011 condition of service of the first defendant tendered as Exhibit C5. However, the new condition of service of the first defendant 2018 Exhibit D1 requires the claimant to appeal any grievances arising from the decision taken by the defendants before resorting to court. The counsel referred the court to paragraph 2E of page 68 of Exhibit D1. He contends that the claimant did not exhaust the internal mechanism before resorting to court. Counsel argued that exhausting the avenues provided in the 2018 rules, that is Exhibit D1, is a condition precedent which has to be fulfilled by the claimant before instituting this action. That failure to comply with Exhibit D1 makes this action incompetent. The defense counsel argues that the second to fourth defendant cannot be said to be persons interested within the meaning of Section 83, Sub 3 of the Evidence Act, for which Exhibit D1 will be said to be documents made in contemplation of litigation, because in amending Exhibit C5 to become Exhibit D1, the defendant was acting in an official capacity and relied on the case of UTC Nigeria Limited against Lawal Citation Supply. In his response, the claimant counsel has argued that this case does not deal with a situation of where Section 83, Sub 3 of the Evidence Act would be applied. that the section raises issue of the person interested, and that the conduct of the defendant regarding the subject matter of this suit makes them to be persons interested, and there is every possibility of bias if the claimants have to make submission before the defendant before approaching the court. The possibility of bias must be available before a person making a statement can be said to be a person interested. Counsel argued that it was upon the receipt of the 3 correspondences tendered in evidence within the claimants, wherein the claimant indicated their intention to approach the court, that the defendant hurriedly amended Exhibit C5 to introduce Chapter 11 in Exhibit D1, dated the 12th day of April 2018. This, he argued, was to frustrate the claimant's access to court. Counsel argued that a person who blocks the will of a party's access to court should not be allowed to subsequently rely on that document to challenge the jurisdiction of the court on the said document. Counsel also invited the attention of the court to the fact that Exhibit D1 was rejected in the previous proceedings before another quorum for being a document that offends Section 83 sub 3 of the Evidence Act. Counsel relied on the case of Ita against Benyon citation supplied and the case of Oyetunde against Akami citation supplied. I have carefully considered the argument of counsel for the parties on this issue. I recall that on the 20th day of November 2023, when the court admitted Exhibit D1, the regulation governing the condition of service for senior staff of the Federal University of Wukari, which came into effect on the 12th day of April 2018, I reviewed the position of the law as regards the application of Section 83 sub 3 of the Evidence Act to the effect that nothing in the section shall render admissible as evidence any statement made by a person interested at any time when proceedings were pending or anticipated involving a dispute as to any fact which the statement might tend to establish. See the case of MBC PLC against Ubani citation supply. I noted that I shall not reject the document in evidence, but would have to examine the content of the document to see if the document offends the provision of Section 83 sub 3 of the Evidence Act. It is in evidence that the claimant in their solicitor letter of dated 7th day of February 2018 and 19th day of March 2018 had indicated indicated very clearly of their intention to approach the court. It is also in evidence as admitted by the defendants that regulation governing the condition of service for senior staff of Federal University Wukari was amended and to come into effect on the 12th day of April 2018. It is also in evidence that in amending Exhibit C5, the 2011 edition of the regulation, the defendant only inserted Chapter 11 to the new condition of service. It is Chapter 11 that seeks to hamper the rights of the claimant to approach the court that was not previously a provision in the 2011 edition of the condition of service. I've carefully considered the timing of the amendment and when the claimants gave notice of their intention to go to court. So long as the amendment was to postpone or hinder or provide an impediment to the rights of the claimant to ventilate their grievances in court, there can be no better explanation that can be gleaned from the conduct of the defendant in contemporaneously amending the regulation at the time it got notice of contemplated litigation than that the amendment was made in contemplation of litigation. I agree with the submission of Mr. Ganagabi, the legal counsel for the claimant, that though the powers of the defendant to amend its condition of service is not in dispute, but when made to overreach or in anticipation of the proceedings so as to obstruct access of the claimant to the court to the Court of Justice, it becomes unlawful. It is therefore the finding of this court that the amendment of Exhibit D1 to include Chapter 11 was made in contemplation of litigation. The amendment offends the provision of Section 83, sub 3 of the Evidence Act. That amendment cannot therefore be used as a basis to determine the competency of this action by the claimant. This finding does not in any way affect the amendment made by the defendant in Exhibit D1. The defendant has the powers to cause the amendment to a regulation governing the condition of service for senior staff of the University of Ukari. Also, it is on record that the defendant in this action had attempted to tender Exhibit D, the revised regulation in evidence, and it was rejected in evidence before the previous hearing. It is tendered and admitted in evidence in this proceeding. The established position of the law is that a document rejected in evidence and marked as such cannot be readmitted in the same proceedings before the same court. See the case of registered trustees of Ife Oluwa Mission, Chrislam, and another against Morufo Owonla, and others. Citations supplied. Even though Exhibit D1 has been admitted again in this proceeding, it will be treated as evidence that is wrongly admitted. This court has the powers to expunge Exhibit D1. In the case of Benue State University of Bokulu against Sudab Limited, citation supplied, the Court of Appeal reiterated this practice when it held. In law, a court can expunge a document that, though admitted, but which turns out to be inadmissible and thus inadvertently admitted in evidence. It is on the strength of this authority that this court holds that Exhibit D1 was inadvertently admitted in evidence. It is therefore expunged as an exhibit in this judgment. In view of the above findings of this court, this court hereby resolves the second issue in the penal objection against the defendant. It is resolved that the claimant was not under any obligation to exhaust any internal appeal mechanism before instituting this action against the defendant.
As the court pleases.
The third objection now. In this objection, the defendant is alleging that the claimant is not a juristic person because in paragraph 1 and 2 of the statement of defense, they had denied that the claimant is not registered with powers to sue in his own name. It is their argument also that the claimant did not put forward any document to establish their juristic personality. In response to this argument, the claimant counsel has stated the capacity in which he is suing. Counsel stated that the claimant record is Stephen Egar Tadawus, suing for himself and on behalf of the entire SANU members of the Federal University, Taraba State. This is not the same as SANU suing on behalf of herself. Counsel invited the attention of the court to paragraph 1 and 6 of the statement of facts, where the capacity in which the claimant is suing is disclosed. Counsel argued that what a representative must show to sue or defend an action in a representative capacity is that he must obtain authorization from the people he intends to represent. The claimant have authority to represent the members of SANU, which is in evidence before this court. As stated in paragraph 6 of the statement of claim, counsel relied on the case of Okukuje against Akuido, citation supply, and also and other authorities. Counsel also relied on the 13 Rule 1, under 13 Rule 11, sub 1 and 2, and to further buttress his position. I have carefully considered the argument presented on this issue. The defendant counsel in raising this objection has succeeded in wasting the time of this court. This objection is like saying, for instance, that because the first defendant has not tendered the law establishing the university, then juristic personality should be denied her. The claimant in this action instituted this action as disclosed on the complaint as Stephen Edgar Tadawus suing for himself and on behalf of SANU members of the Federal University of Wukari, Taraba State. This shows that the claimant is instituting this action in the representative capacity. If it is the name Stephen Edgar Tadawus, who is disclosed as claimant in this action, that the defendant counsel is asserting is not a juristic person, then the defense counsel is ignorant of the categories of legal personality in law. The settled position of the law is that a person can institute an action in a representative capacity on behalf of others who have the same interest in the subject matter of litigation, provided he is a juristic person himself and can also show the authority to act in that representative capacity. In the case of Okukuje against Akuido, citation supplied, the Supreme Court had this to say: a representative is a person authorized to act on or speak for another or others. Thus, the party wishing to sue or defend in a representative capacity must obtain the authorization to sue or defend from the person or persons he wishes to represent. The authorization for the claimant to institute this action was given in the meeting of SANU Congress held on the 20th day of March 2018 and tendered in this court as Exhibit C1A and C1B. This authorization gives the claimant, Stephen Edgar Tadawus, the locus to institute this action on behalf of the members of SANU as the dominus litis. See the case Ogunyobo against Okoya. Citation supplied, where the court held. When therefore an action is instituted in the representative capacity and or against persons in the representative capacity, the action is not only by or against the named parties, they are also by or against those the named parties represents who in the suit are not stated nominee. See also the case of Ekenia against Okparaka and others. Citation supplied. This position of law is further enforced by Order 13 through 1 of the rules of this court, which provides that where there are numerous persons having the same interest in one suit, one or more of the persons may sue or be sued on behalf of or for the benefit of all persons so interested. The claimant in instituting this action complied with the requirements of the law. It is the finding of this court that the claimant on the record is a juristic person and has the requisite capacity in law to institute this action on behalf of SANU, which is a trade union registered under the Trade Union Act. The objection of the defendant on this issue is misconceived. By raising an objection on such elementary issue, the defendant counsel has only succeeded in wasting the time of this court. This objection is hereby dismissed.
As the court tables.
Issue for determination in the main action. In his final written address filed, the defendant formulated one issue for determination, whether or not the claimant has proved his case to be entitled to relief sought in this action. One, whether or not the claimant has proved his case to be entitled to relief in this action. The claimant counsel formulated two issues for determination: whether the defendant can alter the contract of employment without recourse to the condition of service, and two, whether the claimants are entitled to damages. I've carefully examined the issues formulated by the parties. I don't think this issue can effectively address the contending issues between the parties in this action. In a nutshell, the facts elicited in the statement of facts and defense show that the members of the claimant were offered appointment by the first defendant. The appointment were confirmed before the defendant introduced the policy of proper placement at the point of entry into the university. It is the apprehension of the effect of the policy on the already confirmed appointment of the members of the claimant that the claimant is disputing. Therefore, this court is of the opinion that the right issue for determination is whether the policy of proper placement at the point of entry into the university, federal university, will carry materially affected the individual contract of employment of the members of the claimant union, for which the claimant can institute this action to stop and to claim the release in this action. The claimant, Stephen Edgar Tadus, who is the Dominus Litis, in this action, instituted this action in a representative capacity on behalf of the members of Senior Staff Association of Nigerian University, SANU, of the Federal University, Wukari. The position of the claimant is that members of the claimant were appointed by the defendant. The appointment confirmed and even received promotion from the first defendant. The claimant tendered his letter of appointment and some of the letters of appointment of some of the members as exhibits C3A to C3I. The claimant also tendered his letter of confirmation of appointment and some of the members of the claimant association as exhibits C4A to C4G. From the exhibits, the claimants were appointed between 2011, 2012, 2013, and 2015. It was in October 2017 that the first defendant adopted the policy of proper placement at the point of entry into the university. The defendant testified that the policy was introduced after it was discovered that some members of the claimant were on transfer of service from other institutions, organizations, and other bodies, and they failed and or neglected to bring forward their letters of transfer from their former employees because of the irregularities in their employment. Apart from this, it is also in evidence that after the inauguration of the Governing Council, it was discovered that the entire non-academic senior staff of the first defendant was overblotted with unqualified, unskilled, undisciplined, and disloyal staff. The ratio of academic staff with non-academic staff is over and above the ratio authorized by the Nigerian Universities Commission, the body charged with the statutory responsibility of regulating the activities of the first defendant. And if nothing was done, the first defendant would have been sanctioned with attendant consequences. The defendant tendered Exhibit D3, the report of the review of placement of non-academic staff at the point of entry into the service of the Federal University of Wukari. I have read Exhibit D3. The modus operandi adopted by the committee on page 6, 7, and 8 of the report was no more than a comprehensive staff audit of the non-academic staff of the first defendant, following the anomalies discovered at the point of employment of members of the claimant. This practice is a normal practice of employers with large number of employees. The report on page 8 to 14 clearly unearthed a lot of irregularities and absence of proper qualification of some of the employees who are members of the claimant union. I must state that the duty to set the academic and non-academic policies of educational institutions like the first defendant is purely responsibility of the second, third, and fourth defendant. It is that the exercise of that responsibility that resulted in the policy of proper placement at the point of entry into university, which was justified having regards to the finding contained in the commission report, Exhibit D3. Yes, I take that again. It is the finding of this court that the exercise of that responsibility that resulted in the policy of proper placement at the point of entry into the university, which was justified having regards to the finding contained in the committee report Exhibit D3. The claimant has argued that by implementing the policy, the salary of members of the claimant was to be slashed by 50%. The claimant offered no evidence to prove this assertion. Neither did the claimant place any material evidence before this court to show that the proper placement of some staff of the first defendant in the letters dated the 6th November 2017 and tendered as Exhibits C6A to C6G were wrong or defective. It is in evidence that when the first defendant embarked on the comprehensive audit, which report was tendered in Exhibit D3 to show transparency, the claimant union, SANUS, was represented by Mr. David D. Ajiboshe, who signed the report as observer. During cross-examination, the claimant, who testified as CWN, admitted that he was not the chairman of the claimant's union at the time the audit in Exhibit D3 was carried out. He admitted that it was the interim chairman of SANU at that time that signed the report in January 2017. He stated that he became chairman of the union in December 2017, long after the exercise has been concluded and the report signed by all the members of the committee, including the representative of SANUS. I have examined the report in Exhibit D3. Apart from identifying the ills associated with the employment exercise of the non-academic staff in the first defendant, the report recommended proper placement in line with the qualification for appointment in the various positions in the first defendant. By signing the report, the claimant union accepted and owned the report. It is absurd that the claimant can now seek to set aside the implementation of the policy, proper placement at the point of entry into the university without providing justification for urging this court to set aside the policy and letters issued in that respect. The claimant position is also that upon their appointment to their different positions and their subsequent confirmation of the appointment and promotion, the policy acted to breach the individual contract of employment of members of the claimant union because parties are bound by the contract which they willingly enter into. That the policy sought to unilaterally review the contract of the claimant by constituting a committee to review the employment. I do not agree with the reasoning of the claimant on this point. It can be recalled that the letter of appointment, Exhibit 3, C3A to C3H, in paragraph 2 clearly states, and I quote, "The appointment is subject to the provisions of the university laws, statutes, ordinances made hereunder, and to regulations governing the condition of appointment of senior staff made by the University Council from time to time. A copy of the current regulation referred to this letter is enclosed. The regulation which was tendered in this action as Exhibit C5 clearly spells out the qualification for appointment to all non-academic senior staff positions in the first defendant. It is expected that all the employees of the first defendant are to meet the basic criteria for employment into the various positions contained in daily trust advertisement for vacancies for academic and non-academic staff 2020/11/2011, tendered as Exhibit C2. Page 98 to 182 clearly spelled out the basic qualification for appointment to any vacancy in the first defendant. If for any reason the defendant found out after the interview and appointment that any of the employees did not possess the requisite qualification, the first defendant had the powers to review the appointment. The claimant admitted this when, during cross-examination, the claimant was asked whether the university has the power to discipline, to carry out proper placement and review placement of its staff. The claimant answered in the affirmative. It is the finding of this court that the first defendant had all the powers to review the appointment as it did when they instituted the policy of proper placement at the point of entry into the university. This is so because the appointment of the claimant, as shown in paragraph 2 of Exhibit C3 series, was subject to compliance with the University Statutes Ordinance and regulation governing appointment into vacant positions in the university. The claimant also claims in paragraph 18 of his witness deposition that as part of the threat, members of the claimant were surreptitiously lured into membership of the claimant with the promise of reward of undeserved promotion. The claimant further alleged that in a bid to further convince members of the claimant who were still in doubt that their promise was real, the defendant published Federal University Okari Special Bulletin in December 2018, where they, without regard to order, caution, and due process, were promoting members of the claimant who had trusted them and withdrew their membership of, and those who turned loyal with unimaginable promotions. While these were going on, the members of the claimant who maintained their membership of the claimant were daily subjected to all manners of threat, frivolous queries, punishment, posting, and very degrading and inhuman treatment. The claimant tendered Exhibit C7, the Federal University of Okari Bulletin, which published the promotion. I have carefully examined the testimony of the claimants reproduced above. Apart from this bare assertion, I cannot find any act of intimidation, inhuman treatment, threats, and evidence of frivolous queries issued to members of the claimant's union. I cannot also agree with the claimant that any of the members of the claimant union were coerced to withdraw their membership of the claimant union as shown on Exhibit D2A to D2M. Rather, the evidence before this court showed that the members of the claimant union were exercising their constitutionally protected right to freedom of association when they withdrew their membership of the claimant union. The claimant cannot hold the defendants liable for the stoppage of the deduction of check-off dues from the 136 members of the claimant's union as listed in Exhibit D2M. Some of the members of the claimant union, having resigned their membership of the claimant union, SANU, there was no obligation on the first defendant to continue to deduct and pay check-off dues to the claimant. The claimant also wants this court to believe that the promotion contained in the bulletin obligation of the first defendant were the promotions given to the recipient staff as a favor for embracing the policy of proper placement at the point of entry into the university and for also withdrawing their membership of a claimant's union. I've carefully examined that bulletin, Exhibit C7. Over 2,000 staffs of the first defendant, cutting across both academic and non-academic staff of the university, were promoted in that exercise. To think that the promotion of this number of staff was based on favoritism and incentives to accept the policy of proper placement or to withdraw from membership of the claimant's union is not supported by any evidence led by the claimant in this action. Such suggestion is rejected and it is accordingly discountenanced. The above state of evidence and facts can only show that the claimant in this action has failed woefully to establish his case against the defendant, for which the relief sought in this action can be granted. For the reasons already stated in this judgment, the claims of the claimants, as already stated in reliefs number 1, 2, 3, 4, 5, 6, 7, 9, 10, 11, and 12, are refused, and accordingly they are dismissed.
As the court pleases.
However, this court is minded to grant relief number 8. Accordingly, it is hereby ordered that all members of the claimant union who have participated in this suit in whatsoever manner or role shall not be victimized either immediately or remotely by the defendant by any means whatsoever.
As the court pleases.
The defendant, this is the counterclaim now. I'm looking at the counterclaim now.
As the court pleases.
Ms. Egan, see with us. Is Ms. Egan still with us?
He is still with us, my lord.
Okay. Okay. Counterclaim. The defendant in this action counterclaim against the claimants as follows. An order directing all members of the claimant who have already received their terminal benefits from their former employers to revert to contract appointment or to apply for transfer of service if they have not received their benefit from their former employers. An order directing members of the claimant with previous service to submit letters of release from their previous employer or acceptance of resignation or transfer from their previous employers to be defendant. An order directing members of the claimant that are on transfer of service to produce to the defendant their record of service to career progress report and last pay certificate to be attached to the said report. An order that members of the claimant entering the public service over the stipulated age should be placed on contract. An order that members of the claimant on contract should be placed in a level lower than that which they ordinarily qualify for. An order directing members of the claimant to present themselves before the defendant with their original credentials with a view to scrutinizing their credentials with the National University guidelines and the advertisement for their employment in order to sanitize and have proper record of members of the claim. An order that the counterclaimants have the right and power to see that members of the claimants are properly placed in their relevant department and or unit in the first defendant with the view to optimizing the skill and performance of those members. An order that the defendant have the power to conduct the review of members of the claimant at point of entry into the service of the first defendant in order to place them properly in line with the advertisement for their employment, NUC guidelines for employment of non-academic staffs of the university. An order directing members of the claimant, SANU, who enjoyed and are still enjoying arbitrary salary adjustment to refund the amount they collected to the first defendant and to revert to their former position, and order directing all members of the claimant who have been receiving their terminal benefits, pension, and gratuity from their former employers and have been offered permanent and pensionable employment in contravention of the law governing such appointment to refund such money, and other directing members of the claimant who got employed in the first defendant after their retirement in other institutions or parastatals to refund all the salaries and allowances paid to them by the first defendant, and other directing all members of the claimant SANUS who entered or got employed in the first defendant or got employed for the first time after the age of 45 years to be placed on contract employment as provided by the civil service rule, and order that the defendant have the power and the right to implement the report of the Committee on Review of Placement of Non-Academic Staff at the point of entry into the first defendant in order to bring sanity and optimal result in the first defendant in line with the first defendant's regulation, and order directing that the first defendant to disengage members of the claimant who were or are 50 years old at the time of their employment with the first defendant, and order directing members of the claimant to observe the provisions of the Code of Conduct for Public Officers. I've carefully examined the evidence presented by the defendant in this case. The evidence clearly established the grant of some of these reliefs in the counterclaim in this action. Relief number A, B, C, D, F, G, H, and M sought in the counterclaim are not strange reliefs. These are the normal practice obtainable in the public service of the Federation. It is in evidence that it is the ilk associated with the improper documentation, certification, proper placement, and transfer of service following the employment of members of the claimant union that resulted in the audit conducted in Exhibit D3. I have already held in this judgment that the first defendant had the powers to carry out the audit exercise, and the implementation of the recommendation contained in Exhibit D cannot be set aside as the claimant sought to do in this action. These reliefs are such that, if granted, will enforce the policy and recommendation contained in Exhibit D3. Accordingly, it is the finding of this court that the above-mentioned reliefs are meritorious under the circumstances having been established by the recommendation in Exhibit D3. The reliefs are hereby granted.
As the court pleases.
Regarding relief E and I, there is no evidence before me to establish that any members of the claimant was receiving arbitrary salary adjustment, more so that the defendant have completed the staff review and implemented the proper placement policy. Also, the defendant did not also place before this court any evidence that proved that when people are engaged on contract basis, they should be placed on a level lower than that which they ordinarily qualify for. It is not shown whether this practice is rooted in the public service rules or any statutory provision or the law or regulation of the Federal University who carry. For this reason, the reliefs cannot be granted by this court. The reliefs are dismissed.
As the court pleases.
Regarding relief number J and K, because of the fact that the members of the claimant to be affected by the relief, by these reliefs, have already rendered services to the first defendant and were paid for such services, this court cannot order the refund of the salaries already earned and which were duly paid. A workman deserves his wage. In the case of Nwafo and Anambra State Education Commission, citation supplied, the court had this to say: an employee is entitled to wages and salaries and allowances during the period of his or her lawful engagement in service. No member is under any obligation to pay salaries and wages allowances to an employee who has not worked for the period of his employment. For instance, a dismissed employer can only claim emolument he had worked for in the course of his employment. What the appellant was entitled to was the arrears of his emolument for the period he actually worked for the employer. The members of the claimant who are to be affected by this order were lawfully engaged and having rendered the services and received the payment for their services to the first defendant, this court cannot make an order that they be compelled to refund the salaries they receive. Relief number J and K are hereby refused and accordingly dismissed.
As the court pleases.
Regarding relief number N, from this judgment, I have already granted relief number D, where I have ordered that members of the claimant entering the services of the first defendant above the stipulated age should be placed on contract. This relief is similar to relief D. If any member of the claimant had entered the services of the first defendant after attaining the age of 50 years, he ought to be placed on contract. To order the disengagement of all the members of the claimant who are 50 years would amount to interfering with the contractual rights of the claimant of the parties to their employment contract. Rather, this court hereby orders that if there are persons of 50 years who were appointed as full and pensionable staff at the point of entry into the service of the first defendant, such appointment shall be converted to contract appointment. Finally, regarding relief number O, there is no evidence before me that members of the claimant union are not complying with the requirement of the Code of Conduct for public officers. If there is any infraction in this regard, the proper venue to address this is the Code of Conduct Tribunal and not the National Industrial Court. This court lacks the jurisdiction to make that pronouncement. Such on this issue or make the order sought for in this action. Accordingly, this relief is refused and accordingly dismissed. On the whole, the counterclaim of the defendant succeeds in part. Parties are to bear their respective course of this action. Judgment is hereby entered.
My Lord, we are grateful for the well-researched judgment.
Yes. The judgment will be made available to you in a short while. It will be sent to our division in Makurdi, where you can be able to apply for copies.
As the court pleases.
Unmute yourself if you want to talk.
As the court pleases.
Mr. Ega, you have muted yourself. We cannot hear you. Mr. Ega, we cannot hear you. You have muted yourself.
I hear you, my lord. I think it's network.
Okay. Okay.
We are grateful. We are grateful, sir.
Yes. All right, gentlemen. That is the judgment of the court.
As the court pleases.
We are grateful.
All right, have a good day. All right.
Okay.
Thanks to you.
You can exit. You can exit. Yeah. Mizega has not exited. He should exit.